Hello, scholars. I hope everyone's having a lovely day. Today, we shall be discussing free speech as a constitutional right found in the First Amendment. Now, as we know, I'm obviously going to be simplifying a very complicated area of law, looking at some key cases to discuss essentially how free speech works in the United States in a very broad sense. Now, there are different cases when it involves free speech in the schools, in the public schools, and I'll go over those next time. So today we're going to be basically looking at free speech rights outside of schools. Now, these are the same free speech rights you have outside of schools as well. So this is not one of the situations where you have different rights as a juvenile versus an adult. You have free speech rights as a juvenile, but inside the schools, they're going to be a little diminished. We'll talk about that again next time. Outside of schools, though, you have basically the same free speech rights that anybody else does. So let's look at let's look at my notes on this, shall we? Okay, so again, freedom of speech. This is our topic today. Now, there's a variety of reasons why we have free speech protections. Free speech and democracy, they do tend to go together like peanut butter and jelly. You very rarely see a burgeoning democracy without free speech, and you very rarely see free speech without democracy. They tend to go very well together. There's a number of reasons for that. One is it is a protection of both the minority and individual rights, that you can advocate for your rights, you can advocate for your position in society using free speech. So, the dissident movements in our society have been reliant on free speech protections. Without them, obviously, we wouldn't have seen any number of, civil rights movements or movements out there to protect civil liberties. Also, it's important in a democracy that we have a discussion of who should we elect or what would be the correct policy of the United States. So if we have free speech, we can discuss what should be the correct outcomes for the society, who should we vote for, that kind of thing. It's also a mechanism for keeping government accountable. If the government is in some way failing to protect our rights, free speech allows us to criticize the government, criticize its policies. And lastly, if not leastly, to inform the public about any information it needs. Is that often, certainly right now we're in the middle of the COVID-19 quarantine. Obviously, free speech allows us to understand what's going on, what are the issues, what's the information, and help us make relatively informed decisions. Now, the First Amendment does apply to not only speaking, but also hearing. So the free speech right doesn't just allow people to speak, but it also gives the listener the right to hear. So, you can't say, and sometimes colleges will try and do this, where they'll say, oh, tell you what, you have an opportunity to speak on our campus if you want. It just happens to be in the basement of the garage. That sort of thing the courts have basically frowned upon. So you have a right to speak, and you also have a right to hear. Um, so when examining the First Amendment, it's important to remember two sort of critical elements. The first is that free speech is supposed to protect unpopular viewpoints. Okay, we don't need free speech to protect, I don't know, Britney Spears songs, or I guess she's out of date now. We don't need to Taylor Swift, right? We don't need free speech to protect Taylor Swift videos. What we need is free speech to protect expression that we don't like. So the fact that it is an opinion that is controversial, disliked, loathed, abhorred, that actually in some ways should key us in that it needs to be protected, because that's the point. The second thing is, like all other rights, no right is absolute. There are certain forms of speech that are not constitutionally protected. Speech that is a threat, the possession of child pornography. These would be things that are not protected forms of speech, and as such, they are they can be legally prohibited. Now, the US does tend to have very, very broad protections of free speech. So, for instance, recently, Germany passed a law making it illegal to burn other countries' flags. So you can't burn the EU flag, you can't burn the French flag, apparently in Germany. Whereas in the United States, not only can you burn other countries' flags, you can burn the American flag as well, and that's a constitutionally protected form of speech. So again, here in the United States, we do tend to have a broad understanding and broad protection of free speech. Now, partially that comes from this case, Schenck v. United States in 1919. And what Schenck established is that in the event that there is speech that forms a clear and present danger, then the speech can be suppressed. So if you're inciting criminal acts, then that is something. So if you are advocating for, say, I don't know, overthrow of the United States, if it's a nice abstract sort of incitement where you say, you know what, we should tear down the state, and everybody's like, yeah, yeah, but you're nice and vague and sort of non-descriptive about it, that's probably protected. But if you say, hey, let's tear down the state and start by killing that guy right there, well, then that's clear and present and really would be, you could get arrested for that sort of speech, that sort of direct incitement. One of the classic examples of clear and present danger is yelling fire in a crowded theater, right? Back in the day, before we had sort of the fire codes that we have today, sometimes there'd be these fires or these panics about fires in a crowded theater. People would trample each other, sometimes killing more people in the trampling than the actual fire. So the exception for clear and present danger, the example of what would not be protected would be something like yelling fire, where if you do that, people will trample each other. Now, a sort of revision of this, or you could sort of say an update or a 2.0 version, is this case Brandenburg versus Ohio. In Brandenburg, you had this guy who was a Ku Klux Klan member. He made some sort of generally menacing statements and was arrested under this law of, basically you cannot advocate crime, sabotage, violence, or other unlawful means of terrorism as a means of accomplishing industrial political reform. The court held, and again, it's sort of similar to clear and present danger, that speech can be punished if it's inciting an imminent unlawful act. Okay, so if there's, again, imminent means, sort of immediate, and unlawful, well, that's sort of easy. It's got to be criminal. So again, what Brandenburg tells us is if you're making some sort of a vague incitement, we should, kill the bankers. That may be fine. But if you say we should kill the bankers and let's start with Chuck right there, then that's not going to be fine. All right. Because one is an imminent unlawful act and another is sort of more of a vague call for societal change. Vague calls for societal change are more likely to be protected, whereas specific incitement to a specific target is less likely to protect it. Okay. Um, this brings us then to another area of government regulation of speech, if it's allowed, is time, place, and manner, or what we also call content neutrality. The government can't choose which message it likes and which message it doesn't like, right? Once the government allows speech of really kind of any form, it has to allow all kinds of speech, even speech it hates. And an illustration of this is this case called Skokie versus Illinois. Sometimes you just refer it to as a Skokie case. In the Skokie decision, what occurs is you've got a group of neo-Nazis who are used to protesting in a downtown park in Chicago, and they lose their permit. Right, they're no longer allowed their monthly protest, and this is a pretty small group of neo-Nazis, and they're very mad about that, and so they say, well, okay, in response to losing our parade permit for downtown Chicago, we are going to march in downtown Skokie. And why that was particularly incendiary was that Skokie had a very large Jewish population, and a number of people who live in Skokie had actually been survivors of the Holocaust. So the prospect of the neo-Nazis marching through downtown Skokie was indeed quite disturbing and alarming. So goes to court. The city obviously tries to stop it, but what the courts basically say is no, because you've allowed some groups to have a parade or a demonstration, you have to allow all groups to have a parade or demonstration, including the neo-Nazis. So that's basically established in Skokie is, again, if you allow one group, you have to pretty much allow all groups. Portland has at times tried to get around that, saying that they specifically want to ban say the citizens, what do they call them? Basically right-wing groups, that they want to ban right-wing groups from marching. Um, and basically that's not gotten anywhere because again, then they're being very specific in what kind of message, in what sort of political viewpoint they want to silence, and the courts, are not gonna go for that. Now, there is a subsequent decision called RAVV City of St. Paul. In that decision, it was basically an attempt to ban cross burning, which of course is a very offensive and alarming symbol of racial hatred. And in an attempt to ban it, what the city of St. Paul did is they made a law that basically made it illegal to arouse anger, alarm, or resentment on the others on the basis of race, color, creed, religion, or gender. So they specifically said you cannot, again, anger or alarm people in these groups. And the court struck that down. The court said, no, that's still content specific. You are specifically saying, okay, we can arrest you if you arouse anger alarm on the basis of religion or race. But let's say we want to, there's a group that's arousing anger and alarm on the basis of, say, age, that would be allowed, or sexual orientation. Right. So the idea is the government in the city of St. Paul is attempting to discriminate between which messages it will support and allow and which messages it won't. And the court struck that down. Now, later, in a case called Virginia v. Black, the court basically comes up with a different standard, and they say that if there is some evidence that cross burning is done to intimidate, so in other words, it doesn't matter sort of who you're trying to intimidate, it only matters that you're trying to intimidate, then that would be content neutral. So if you're trying to intimidate people by the basis of age or race, or their wearing of gray shirts, that would all be problematic if you can prove an intent to intimidate. So in Virginia v. Black, we see the court sort of establishing a means of protection against intimidation, but at the same time, it's still got to be content neutral. The government can't choose one message or position to support and one message to not support. Okay. Which brings us to symbolic speech. Now, symbolic speech, this has traditionally been things like picketing, flag burning, wearing armbands, stuff like that. Basically, symbolic speech is anything that's not written or spoken. And the general rule here is if the government has got a reason to protect that speech, then it has less protection. But it's got to have a good content neutral reason. So if the government says, okay, no burning of, I don't know, draft cards. Well, the government, I mean, this is back in the day when I had draft, the government has a need to have people have draft cards because that way they can be drafted. So if we all burn them, then that would interfere with that governmental function. Again, if you are burning a cross with an intent to intimidate, if you are occupying, say, the Capitol Mall or two parks in downtown Portland, those would not, any of those would not be protected because that's interfering with a legitimate governmental purpose, to maintain the parks, to maintain people aren't intimidated, to maintain the draft system. But if it's something like burning a flag, the Supreme Court has ruled in a case called Texas v. Johnson, then that can be protected because the government doesn't have a key interest in making sure that flags aren't burnt, and as a result, that speech would be allowed. So again, symbolic speech that is not written, not spoken, that is less protected, but the government still has got to show content neutrality. It can't pick on one form of speech and not pick on the same kind of speech with a different meaning. So They couldn't, for instance, say, okay, we're going to arrest left-wing agitators that burn the flag, but we're not going to arrest right-wing agitators who burn the flag, right? It's got to be similar. It's got to be basically content neutral, that you will arrest everybody who, I don't know, decides to occupy a public space. Right? That is constitutionally not allowed. So that's symbolic speech. Couple other kind of cases that are interesting that you may find to be sort of illuminating. One is Snyder V Phelps. So Snyder V Phelps gives us an indication of how far and how sort of loathsome um, this speech can be. So in Snyder V Phelps, you have this group who are called the Westboro Baptist Church, and the Westboro Baptist Church is their main purpose is to protest gay rights. And so one of the ways they do that is they go to soldiers' funerals, and standing usually on public sidewalks, they hold up these signs that are really alarming, really offensive. And, so let's say there's a soldier that was killed by an improvised explosive device. They would hold up a sign that says, God loves IEDs. Or let's say the person that was killed was, Sergeant Brown. They would hold up a sign that says, Sergeant Brown rots in hell. So really intended to be offensive and alarming. So it goes to the Supreme Court, and even though the Supreme Court finds their message to be quite offensive, they nonetheless, in an 8-1 ruling, rule that the speech is protected because it's political in nature, and they're not trespassing. And so, for that matter, even though it's distasteful, even if it's repugnant, even if it's offensive, even if it's upsetting, political speech, no matter sort of how upsetting it is or offensive it is still constitutionally protected. And so we sort of see that asserted or reasserted in Snyder v. Phelps. In terms of technology, one of the things that we often wonder about is there's new technology, is will the court extend constitutional First Amendment protections to those new mediums? And the short answer is basically yes. In the case of Brown versus Entertainment Merchants, the Supreme Court rules that computer games are in fact constitutionally protected forms of free speech. So here you have a new medium, the medium of computer games, and in this ruling, the court rules that in fact computer games are constitutionally protected free speech. In Reno v. ACLU, the court also rules that the internet is constitutionally protected free speech. So here we've got we have new mediums, we have new technology, and the court so far has shown a willingness to extend free speech protections to those new mediums. So that's been interesting to see. Now, lastly, is a question of profanity and obscenity. Is that protected? So let's first talk about what the difference. Profanity is going to be cuss words. Obscenity is basically going to be pornography, and there's two different cases that establish the sort of the standard for this. The first one is Cohen versus California. And in this case, you had a gentleman who was in court one day. I think he was paying a parking ticket, and on his jacket he had the words, "F the draft," and he gets arrested for probably disturbing the peace, and the goes to the Supreme Court, and the question is his phrase, which is after all in its own way political, is that speech constitutionally protected? And the short answer is yes. The court noted that, I believe the phrase was, one man's profanity is another man's lyric, and that basically that is constitutionally protected. So profanity, cussing, is constitutionally protected. Now, before you guys start applying that to the classroom, Cohen does not extend to the classroom, and your parents can still make you, can still punish you for cussing, and it's still not a good idea during a job interview, but nonetheless it is constitutionally protected speech under Cohen versus California. Now, the other case is Miller versus California, and this case has to do with pornography, and the general rule is that pornography, or that obscenity, is not protected speech. But what is obscenity? right? And so the court basically created a standard for determining what is obscene speech and what is not obscene speech. So it's going to be protected if it's not obscene, it won't be protected if it is obscene. Okay, first question. Does the material offend contemporary community standards? This acknowledges that some communities are much more conservative and other communities are much more libertarian in their allowance of speech. Right, and so that's sort of an acknowledgement that different communities have different standards, and so that is reflected. Secondly, it can appeal only to prurient interest. Another word for prurient might be deviant. So this is material that is not, healthy. This is material that a not well person would want to see. Next, it's got to be patently offensive. So not just a little bit offensive, not just a scotch offensive. It's got to be patently, obviously offensive to the viewer. And lastly, it must lack any serious literary, artistic, political, or scientific value. So there can't be any serious political commentary. There can't be any serious artistic commentary. For a while, for instance, the novel Tropic of Cancer by Henry Miller was censored. Today, I think most people would acknowledge that there is artistic value to that work, and so it would not be censorable today under the Miller versus California standard. So under the Miller versus California standard, what you see is actually a lot of material does tend to be protected under it. The material has to be fairly extreme for it to be deemed obscene. And so that's why we don't see a lot of obscenity prosecutions in the United States. Most material is protected under Miller v. California. But again, if it meets the standard, if it's patently offensive, if it appeals only to prurient interest, if it offends the community in which it was viewed, and if it has no serious literary, artistic, political value, only then could there be an obscenity prosecution. Otherwise, it would be considered protected. So that pretty much wraps up some of the main cases in some of the main areas when it comes to free speech protection in the United States. Again, my next topic will be free speech in the schools and how does this material apply? How do this idea of free speech apply in the schools, which is again a sort of a very different venue, and the courts have sort of recognized that there are different standards of speech in the schools, but that doesn't mean there aren't free speech protections. So you guys have yourselves a lovely day, and I will see you later.